I'm here filling in for Dr. Cook, who is, as you know, a professional academic political scientist. I'm a friend and a work colleague of his over at the Department of Defense. I'm going to, not because me talking about myself is something that's inherently good, but I just want you to understand what my background is, because my approach might be different from what you're used to with some of your other teachers, specifically in the area of political science. I am, as Ms. Phillips, as Ms. Peoples said, I'm a retired Foreign Service officer. What is a Foreign Service officer? I spent my career with the U.S. Department of State. I'm a diplomat. My job was to represent the United States overseas, and I spent the better part of my career at various U.S. embassies supporting the ambassador, the U.S. ambassador to that country, and trying to learn that country, the language, the people, the politics, the leadership, in order to provide an understanding of it to U.S. leaders, to the U.S. government, so that we can pursue our own national interests and then shared interests with those countries, wherever they might be. Prior to that, I was a U.S. Marine Corps officer. I studied history and international relations in undergraduate and graduate school, and I worked as an attorney, as a criminal defense attorney, both as a civilian and within the U.S. Marine Corps. Kind of not quite the Tom Cruise, a few good men sort of thing, but in that general area. Right before I joined the Foreign Service, where I spent the last 30 years. I served at a number of places overseas. I'll let you know the places that I served, places that I lived with my family and represented the United States and got deep into the politics of the host country where I was assigned, include the following. I'll sort of go geographically, not chronologically. Pakistan, Afghanistan twice, Egypt, England, Panama, Haiti, and Japan, as well as a fair amount of time in Washington, D.C., wrestling with the gigantic U.S. bureaucracy there, created by the U.S. Constitution. Fascinating. It was a fascinating career. Let's start at home and just sort of talk about before we get into too much nuance, let's talk about just some key features of the U.S. Constitution itself. And let's not kid ourselves that we're going to cover every aspect or even every portion the U.S. Constitution here today. It's only 60 minutes, and some people devote their lifetime to the, study and advocacy and contention over what the U.S. Constitution is and what it means. We've only got a few minutes, but let's jump in. The Bill of Rights, and we've got I think 4 students out there in the audience right now, so there's enough time for everyone to jump in. Who's got a favorite article and why, and what can you tell us? What do you know about its origins and its purposes?
They're all important, but I'll go with number 1. That one's pretty important.
That is that's a very safe and bureaucratic and correct answer, and nobody wants to low rate any of the articles in the Bill of Rights. She chose number 1, the first one. That's freedom of speech and freedom of the press, freedom of religion, and the right of the people to petition, for their grievances. That underlies that is inherent in the nature of a democracy, and a democracy that does not enjoy freedom of speech is really unable to enjoy many, if any, of its other meaningful liberties. And so I think that's an excellent choice. I think Stacy was very judicious in her choice here. The Fourth Amendment. Does anybody like that one? And does anybody know what that's about? It is the amendment that requires the police to have a piece of paper before they can come into your house, and you can tell them just to go away if you want to, if the police show up at your house. And I guess I was interested in provoking a discussion of whether that is, as a practical matter at least, exactly true, and what the nature of that Fourth Amendment protection is. The Fourth Amendment protects against unreasonable searches and seizures. It is to sort of use a cliche. It's based on something that is, long since become a cliche, but it's an important political principle. Comes to us from the Brits. And they have a cliche or a proverb there, the effect of an Englishman's home is his castle, and it is inviolable. That was a principle of custom and of law in England for centuries, for many hundreds of years, before the American Revolution, before the concept of democracy ever really became widely accepted or even discussed or even conceived of. Even in the days when the king was preeminent, ruled in effect by divine right, even before the Parliament itself had become firmly established, the legal concept of citizens being safe in their home and their possessions, if nowhere else in the country, if nowhere else in the kingdom. So this is as ancient a right as we have. And that is a right that the Fourth Amendment is intended to protect. And the mechanics by which it protects it are as follows. The police, in order to enter for any purpose, and since it's the police, one would expect it normally to be a law enforcement purpose and hopefully not a political purpose, but it could be for a political purpose. For any government authorities can enter your home, they must have permission from a magistrate, a judge, all right, to enter your home at a particular time for a particular reason. And that reason must be based upon a reasonable, if you will, a preponderance of evidence. That evidence of crime, either a past crime or a current crime that is, continues to be committed, is that evidence of that criminal transaction is going to be found upon your premises. They have to put forth evidence to that magistrate, to that judge, before the judge will issue formal written permission, a warrant, a search warrant, to the law enforcement authorities. At that point, they do have the right to come in and search your house, your premises, for that limited purpose. The only exception to this being what are called exigent circumstances. That is an emergency situation. An emergency being defined not as, well, it's convenient for the police to come in right now, or the police really don't like you, they think you're truly obnoxious, or they've got a lot of other things to attend to and they don't have time to go and search for a warrant. What constitutes an emergency is something in the nature of a continuing crime, serious crime, which they can only prevent by entering, and which and the threat of include the threat of injury to another citizen, which can only be prevented, which is obviously a time-sensitive transaction. And if someone is being, let's say, a wife is being beaten right now, you don't want to require the police to go off and get a search warrant from the judge before they can come in and rescue that woman from, or that husband, if you will, from their violent spouse. So that would be exigent circumstances. That would be the emergency gap. Otherwise, this ancient right, which comes down to us many, many centuries before the Revolution, is embodied and encapsulated in the Fourth Amendment. So in a way, that's my favorite, but that's just but I still think Stacy was right. The First Amendment really underlies democracy in an even more fundamental way. The idea of freedom of speech and of the press. Because only through freedom of speech and freedom of press can the prerogatives and authority and legitimacy of the government and of political power held by the authorities, in the absence of freedom of speech and freedom of the press, those prerogatives, that power, that abuse of power cannot be addressed or challenged. So Stacey is still more right than I am, but I have my personal preferences.
Mike, a question.
Christy.
So when you had asked earlier, so I was going to say I like 4, but I find that 4 through 7 all kind of coincide, like they're all kind of necessary, when speaking of our judicial system and a right to a trial, all that kind of thing. But when you're speaking about number 4, how would you define a reasonable cause? Like it says an unreasonable searches. That feels like that's really open to a lot of definition.
It is. It's the kind of thing that you could debate and litigate endlessly, isn't it?
Yes.
Isn't that what it sounds like?
Yes. So
You're
I think
exactly
that's
right.
kind of very interesting because there is so much that's open to definition, and that word is very intriguing that they chose specifically to say that it's, yeah.
Well, reasonable is a critical word in the law, and in the civil law as well as in the criminal law, and it's something you simply can't get away from. The fact is, it's absolutely impossible to elucidate a perfectly balanced statement of the law or justice that's going to be applicable in every circumstance. Human circumstances constantly change. And so the best we can do is to say that, well, this is something on which reasonable men can disagree, but it is not in itself unreasonable. And factors have been considered, which we all agree are important or even crucial. And the person we've got making the decision, that is the magistrate, occupies a reasonably independent position rather than being, directly beholden to the authorities. For instance, I can remember a wonderful case that they have you read when you're in law school. Had to do with traffic tickets in an American state that will not be named because I don't want to annoy anybody. But there was a state law that provided for magistrates to adjudicate traffic tickets, and they got $2 for every acquittal and $5 for every conviction. Okay. So that's not a fully independent or impartial magistrate, because you make more money if the defendant is convicted, right?
Right.
We can agree that's unreasonable, and we can agree that that magistrate is not in an impartial position. So, but you're right. Reasonable it's a deeply unsatisfying word, but it's probably the best. It's probably the best yardstick we have to try to find something somewhere in the middle that most people can live with most of the time.
Yeah, agreed. I think
That's
that's why I like it.
What do you think?
Yeah, I think that's why the reason I like it is because of the founding fathers thinking of, leaving things up to certain interpretation, because every person's experiences are going to be different and perspectives. And so we need to be open to dialogue and engaging with others and not just defining it to a very specifically strict term. So thank you.
She says, I
Yeah.
was watching a video earlier, and in the video, a teacher thought someone stole something and all the students had to get their bags checked. And she's saying, I don't think they had any warrants. Would that be considered an emergency under the Fourth Amendment, or is there different rules for schools?
That is a great and very intelligently thought out and worded question. And I'll start at the back end of that question first. Yes, there are different rules for schools. Those rules have been, they're not based explicitly in the Constitution. They ultimately derive from the Constitution, of course. But case law, quite some time ago, in the American court system, American judicial system, decided, and all jurisdictions pretty much agree, that that a school is a special case, that a school administers citizens who are not quite adults and they stand in loco parentis to those students. And because they have a special degree of responsibility to watch out over, to hover, if you will, over the the safety and the education, the welfare, the morals, even if you want to include that, of their students, then they're entitled to be a little more intrusive than the police are. They can come and search a student's locker or backpack without a police warrant. Why? Because it's school, and they are not the police. They are teachers. They're people who have special responsibilities towards these young citizens who, because they are young, are especially vulnerable and need an additional degree of protection. That is the rationale when someone stands sort of in loco parentis. So your backpack is not like your house. You don't carry your house around with you. But schools are something of a special exception to the Fourth Amendment, and a principal or a teacher doesn't have to go and ask a judge for permission to do something to conduct a search or a form of restraint on the student that is designed not to punish that student criminally, but to protect that student in his or her safety, welfare, and education. All right, I'm kind of jumping around here. I will stay in the Bill of Rights if you want to, but we should go a little more broadly because it's more to the Constitution than that. Let me jump to this topic of the two-chamber legislature. Is that let me just ask the question out there. Does someone think that came from the brilliant design of an Enlightenment philosopher who was working on the Constitutional Committee there in Philadelphia, and he came in with this tremendous design like a divine or political architect, and everyone said, wow, a two-chamber legislature, that's the best possible solution to all of our questions. Let's have that. Or was it something a little more banal or prosaic? Where do we get the idea of an upper lower chamber? How did we come to that arrangement in the U.S. Constitution? I'll put that out there as a question if anyone wants to jump on it, and then I'll speak to it if no one does.
Does it relate to checks and balances? Or no?
Well, the two chambers, yeah, the two chambers certainly do serve to balance and check each other. You know, the House and the Senate are a check on each other. But really, what I had in mind is the fact that this was a deal, a political deal made between different state delegations. And you, roughly speaking, had two kinds of state delegations to the Constitutional Convention that very hot summer of 1787 in Philadelphia. And you had small states and you had large states. Does the phrase New Jersey Plan and Virginia Plan strike a bell? And if so, do you remember what that was about? Okay, I'll jump in there if not.
Go ahead. I cannot.
You had what?
Did it have to
Sure.
do with
Okay,
population at
that's
the
fine.
time?
All right. What's that?
Did it have to do with population at the time?
Exactly. Exactly. So basically, the two models for a legislature, they had agreed for various reasons on the concept of three separate branches of government: executive, legislative, and judiciary. But as far as the legislative branch goes, there was essentially a debate between two different models: a population-based legislature and a legislature based on a representation for the sovereign states, with, you know, that would be representing the states as states, Rhode Island as Rhode Island, Virginia as Virginia, rather than representing the population that lived within those states. If it's based on population, then obviously larger states like New York and Virginia are going to have a great deal more influence and raw, naked political power than the smaller states, such as at that time Rhode Island and New Jersey. New Jersey was heavily rural and so had a very, very limited population. It wasn't as urbanized as it is now. And Virginia was the single largest state, all right, in the new United States. It had been the largest colony, and Virginia, followed by New York, were the two largest colonies. So the people living, the governments, the state governments from the smaller states felt that they were in danger of being dominated by other states if they adopted a population-based legislature. So they therefore, the small states, like Rhode Island, like New Jersey, favored a Senate, which simply had representation for the states. And of course, the number chosen in the Senate as we have it now is 2 senators per state. So in that case, Wyoming has the same representation, all right, as the state of New York, even though the entire, population of Wyoming constitutes basically Manhattan below by about 54th Street, if that. A tremendous imbalance if you think of human beings and citizens as the basic political unit. However, many people, many representatives, and specifically the ones from the small states at the convention, argued that the basic political unit in this national compact that was being drawn up was not citizens. yes, the preamble eventually did say we the people, the United States, in order to form a more perfect union. But they argued that the basic political unit was the states, and that the story of liberty was going to be acted out and elaborated and protected at the state level, not the federal level. Okay, so that it was appropriate for the entity represented to be not individual citizens, but rather the states themselves represented in the legislature. So they debated that for weeks and weeks. They made no eventual headway. Alexander Hamilton, in fact, went home in frustration. Eventually, they compromised, like you're buying something at the car dealership. And they said, okay, we'll both give what the other wants. So they said, we'll adopt both. Is that good enough for you? And that was the basis on which the compromise was, an agreement was very painfully, arrived at. And so we thus have two legislatures, which, as we all know, is a very sort of awkward and, encumbered way to make decisions. Every bill has got to be written twice, and then they got to be reconciled with each other between the two chambers. It's called in conference. And yet at the same time, the advantage is that, operates as a kind of check or a balance. The two chambers tend to, as Stacy pointed out, tend to, they tend to moderate each other. If one chamber theoretically were to get out of hand, then the other chamber could, provide a moderating check. Do folks have an idea of, okay, a given civil right? Does the federal government provide a floor or a ceiling? That is, where is a basic something we think of as a basic civil right protected with where does it receive a higher standard of protection in the federal in the federal Constitution or in a state constitution? If you had a civil rights complaint, would you want to go into federal court or state court? Sort of a quick trick question. I apologize in advance. Christy, what do you think? Is that a muddled question?
Yeah, it's a muddled question. I don't know. I'm guessing.
Okay.
Yeah, I don't know.
It's sort of, the answer is, and this is such a lame answer, it depends. Okay.
That's what I was gonna say.
Basically, yeah. Because the federal Constitution is considered preeminent, and it's considered preeminent more because of court decisions that have been passed, that is Supreme Court decisions, and the fact that the federal government, not the state governments, won the Civil War. The federal Constitution is, as a general matter, preeminent. But you're likely you're going to get your default level of protection for a given civil right in the federal Constitution, but that doesn't mean that the state constitution can't provide an even higher level of protection. Let's say, with respect to, and it's always awful to bring this up, right? But Second Amendment matters, right? Gun rights. Gun laws vary from state to state, as we know. And if the federal government, which it has not yet done, except by providing some national no-fly list, that sort of thing that is done indirectly. If the federal government were to provide a, well, no, this is a bad example. Let's just say search and seizure. Okay. If a state government were to, in growing out of a desire to strengthen the police function, were to provide its own state police with a right under certain circumstances, to enter residences without a warrant and without necessarily exigent circumstances, that's going to be, that law is probably going to be challenged and struck down in federal court by a federal judge as a violation of the federal Constitution. However, someone pursuing a defendant, a criminal defendant, or perhaps a civil plaintiff, could also challenge that in state court and invoke the state constitution as against that challenge that state statute, that act passed by a state legislature, as violating the state constitution, because every state constitution has got some level of protection against, in this case, search and seizure, unreasonable searches and seizures by the police.
What do we think about reconstituting? Is there a precedent for a nation reconstituting, given the fact that we are now an established nation and the original Constitution was in part based in European tradition and historical context? Are there any thoughts about the prospects of reconstituting the United States in a way that embraces the current citizenry?
I guess I would say, as far as the Constitution being based in sort of one regional culture, I think I can be pretty confident in saying, and most academics, most political science academics, I think would agree with me, that the principles of democracy, of representative government, of constitutionally based government, whether the Constitution is written or unwritten, of accountability, transparency in government, and in general popular sovereignty and due process of law, that those arguably were, culturally specific in the 17th and 18th centuries. I mean, those were the central themes of the philosophers of the Enlightenment. And certainly, the United States founding fathers were marinated in that. That's absolutely true. But I also would argue that, and I think I would be in a rather large academic majority here, could be wrong, but I think I'm on intellectually firm ground, that those values, the values of the Enlightenment, have been universalized, and that pretty much universally accepted political documents, such as the Declaration of the Rights of Man, which, although that takes us back to the end of the 18th century and the French Revolution, but more recently, the Universal Declaration of Human Rights issued by the United Nations, and then the United Nations Charter itself. The values that are in there are very much Enlightenment values, transposed, to a global environment. But we essentially are applying sort of values which originated in the Enlightenment, but have been embraced as applicable to, and suitable for all mankind. There are certainly governments now, especially the governments of Russia and the People's Republic of China, who make the argument that trying to advance an agenda of democracy, civil rights, and universal human rights is a culturally biased and therefore unfair and illegitimate approach. But I would push back very strongly against that proposition. And I would point out that the governments that are either heavily representative and essentially democratic in nature, or moving that direction, in both the continents of South America and of Africa and in many parts of Southeast and South Asia, when they invoke both national sovereignty and, more to the point, democracy, and the rights and dignity of their societies, they do so in terms that can be traced back to the Enlightenment. So I would argue that the essential values that formed the Constitution and the Declaration of Independence were at the time values of the European Enlightenment. You're exactly right. But I think they have been universalized and accepted by the world as a whole on an accountable and democratic basis. The Universal Declaration of Human Rights is certainly something that was not forced down at the time of its issuance, other regions or other cultures. It is criticized and pushed back against selectively by a number of regimes and alternative models of government. But those other models of government, those other examples of government, are universally authoritarian and universally are trying to justify domestic arrangements that include repression of voting rights, repression of women's rights, frequently repression of ethnic minorities' rights. Let's look at what the Chinese are most concerned with defending in the public realm right now. What they're doing in Xinjiang, they defend that in terms of their own national dignity and sovereignty, and their basically unilateral right. Are arguing on, from the ground of, cultural distinctiveness, Chinese cultural distinctiveness, that they should be permitted by the world community, and they should not be criticized by the world community to suppress, the Muslim minority populations, that they're doing so, in a very open and obvious and at times brutal way. So again, I'm very long-winded in my reply, and I apologize. But, I think that the idea of remaking the United States, listen, every democracy is always a work in progress, and it is always deeply imperfect, but it is always dynamic and it is always changing, and that is its single greatest strength. And that's why Stacy was right in the first place to say that the First Amendment is the most important amendment, because change is effected through the marketplace of ideas and the exchange of ideas and freedom of speech. So I guess what I'm saying is I think democracy is a worldwide project, even though it was an 18th century Enlightenment concept. I think it's now legitimately a global product, and should be, but should and will continue to change in a very dynamic and in some very fundamental ways. But it's going to do so according to agreed upon rules and protections of liberty and civil rights. I'm just going to bring up. I'm going to bring up two of the foreign examples that I mentioned, and you'll see an obvious bias there: Afghanistan and Haiti, because those are both countries where I was assigned and worked, and studied and marinated for long periods of time, and they both have got very big, dynamic and traumatic processes going on right now. Okay, first of all, Afghanistan, constitutional order in Afghanistan, right? Well, one of our biggest projects in being in Afghanistan the way we were for 20 years, we went in right in the fall of 2001, and we're leaving now in the late summer, early fall of 2021. I won't say that we introduced, we urged upon the Afghans the idea of forming a constitutional government, and that is what the government of the Islamic Republic of Afghanistan, the green, the black, and the red flag that you're very familiar with, their government was organized according to constitutional principles, and it had a written constitution, which they wrote, but they certainly did so with a lot of help from Western authorities and experts, institutions like Stanford Law School, donated a lot of talent to that. But it was, in the end, it was very much an Afghan, mostly produced, and then certainly endorsed and democratically accepted document. It was really the first sort of democratically meaningful constitution in Afghanistan's modern history, and I date Afghanistan's, modern, semi-modern history back to 1747 and the beginning of the Durrani dynasty, which was the dynasty that was not really once, overthrown until the 1970s. It was replaced first by a communist form of government, and then that was succeeded after many years of warfare, which included international intervention. That was ultimately succeeded in the mid-90s by the first Taliban government, Islamic Emirate of Afghanistan, which had its own flag and which had its own idea of governance and social and moral order. And they claim not religious authority. I'm sorry, not constitutional authority, but religious authority based on their interpretation, their very narrow, reactionary, and I would say quite inaccurate interpretation of the Quran and the Hadith and of Sharia law in general. And they ruled under that from the time they seized power in 1995-96 up until they were ejected by U.S. and by Afghan indigenous forces in the late fall of 2001. Well, that is essentially the order that they're going back to right now. You notice that the very first thing they did symbolically was to take down the red, black, and green flag of Afghanistan, which had been the flag of Afghanistan for most of the 20th century under the monarchy and the monarchy that they had before their extended period of civil war began in the 1970s. And so that flag is down. The flag which invokes purely Quranic authority and a blinkered and incorrect view of Quranic authority, I'm going to say again, is back. So we're back to essentially a pre-constitutional order in Afghanistan, which sort of helps make the broader point of constitutions being a vital aspect of modern and democratic governance. There really is no modern nation on the planet which lacks a meaningful constitution of some form. It doesn't necessarily have to be a written one. The oldest and arguably, the most successful, or at least one of the most successful democratic governments on the planet is that of the United Kingdom, only the oldest, and they do not have a written constitution. They have they've had for the last 30 years something of a national debate over whether they should have a written constitution and become, heaven forbid, more like the United States. That's sort of a cultural no-no, but that is a trend. And yet there is a very legitimate debate to be held whether or not a constitution embodied in a single sort of one-time authored document is a more effective guardian of liberty and vehicle for efficient and effective and representative governance than sort of the melange of tradition, custom, court opinions, and parliamentary acts that they have now. And it's a very worthwhile and ongoing debate. But whether it's written or unwritten, you've got to have an agreed set of rules if you're going to have any kind of modern, which is to say, citizen accountable form of government. And that has, for the time being at least, certainly for the short and medium term, gone by the board in Afghanistan. Making the same point in a different way, Haiti, which is once again passing under the harrow, it's sort of going through some hellish circumstances and multiple emergencies and crises simultaneously. Gigantic earthquake that it had in 2010. More to the point, it's profound problems of economic and political underdevelopment, which certainly predated the earthquake, which it's struggled with ever since its independence in 1802. And now more recently, a series of destructive hurricanes, an earthquake out that, although it was out in the provinces, still did a lot of damage, hurt a lot of people, is a cause for international assistance, not intervention, but assistance. And probably even more important than that, the political chaos culminating in the political assassination, the violent assassination 2 months ago of their elected president, Jovenel Moise, who was the president at the time that I retired from the Foreign Service and left Haiti, which was my last post. One of the ways they're trying to get back with the current acting prime minister, Daniel, who had been verbally appointed by Moise about 36 hours before he was assassinated, one of the things that he's trying to do is to rewrite in a helpful way the constitutional order. Haiti's last constitution dates from the chaos and the foreign intervention that followed the fall of the Duvaliers. You'll recall Papa Doc and then his son Baby Doc, who fell and fled the country in 1987. The Constitution that they wrote for themselves at that time, and that was about the 15th and 80s history, reflected great fatigue with and disillusionment with a strong central government. And so that 87 Constitution severely limited the powers of the president and elevated the powers of the two chambers of the legislature, imitating the United States, if you will, and France. But on all the checks and balances, Stacy reminded us earlier in this class on the importance of checks and balances, but all of the checks and balances incorporated in that Constitution, made the country even harder to govern. Now, it was not the cause itself of the upheaval and the violence and the chaos and the accelerating misery, the escalating misery we've seen in Haiti, but it was a factor. And it is a way in which the current Haitian government, which is a real lash up since both legislatures lapsed, and the president had been until his assassination had been ruling by decree with no legislature in existence. Daniel is right now, I think he's making a good faith effort to try and turn the page. And one of the ways you do that and try to get your country on a new and fresh and constructive path and reasonably unified path is by writing a new charter, a new agreement, a new family agreement, if you will, a new constitution. And that is a project that he is doing now, even as he's trying to organize fresh elections for the country sometime in the latter part of 2022. But all of this is just by way of making the point that the Constitution lies at the middle of our, political national life. But there's one final point I want to make about our own political national life and the significance of our Constitution. The Constitution in our sort of domestic political dialogue and national narrative has been, ascribed, and rightly so, a very, very important status. It's almost sacred, but sometimes people, especially when they're having debates over the nature of liberty, lose sight of the very important fact that it's not our only critical national political document. We have a national holiday on the 4th of July for a very good reason. And it's not just the fact of independence, the decision to become independent, it's the issuance of the Declaration of Independence, which was not only a statement that we intend to be independent, it was a statement of our grievances, and more to the point, of the principles upon which we were going to build a new nation and begin our independent existence. And it is in the Declaration of Independence that the principle of the equality of human beings is stated. The principle of equality is stated nowhere in the Constitution. The Constitution is basically a housekeeping document. The statement of our fundamental political values, right, is in the Declaration of Independence. And so that even though it is the Declaration is a political and not a legal document, the two have to be read and taken together. And the fundamental basis for our sort of national political existence is both those documents, because the Constitution itself is incomplete. It is not a statement of how we see the world and what our values are. It's a statement of who does the dishes, who's going to do the shopping, who's going to be the primary breadwinner. It's a practical document. That's an awkward place, but I'm going to stop right there.
Do you have time for a question?
Yes, ma'am. Oh, I do.
Okay.
Sure. If you do.
So I was thinking that same thought just as you brought that up. So you brought up, examples like Haiti and Afghanistan and how their constitutions have changed or they've not upheld. What do you contribute that to? Obviously, there's a lot of answer to that, but do you think it is because they lack a document like ours where we have the Declaration of Independence that declares the intent, that defines a lot of things, and that the Constitution then like I love the example you said of the housekeeping, it's the details and the how this is run. So the two documents do need to go together. Do you feel that that has hold in other countries where they don't have two such documents?
Yeah. I don't think that the presence or the absence of a constitution is the root cause of Afghanistan's troubles. Okay, by no means. I don't think it's causative, but I think it is a very, very important tool to have if you're trying to build a modern state and a modern society. There are a lot of other elements. First, sort of beginning with physical security and order you've got to have before you can even begin to address, constructing a reasonably elaborate legal order. So in Afghanistan, a constitution is not itself causational in nature, but it is a critical enabler given other physical and political and social conditions.
All right, so we're at 1:06. I want to thank all of you who are in attendance and shared your Friday afternoon with us today. And I want to most of all thank Mr. Mike Gayle for sharing with us his expertise and insights on the Constitution and, the context of our empowerment as citizens of a nation like the United States and of the world. I don't know if there are any final thoughts from you attendees to share with Mike Gayle, but let's give him a hand.
Hey, Grace, thank you very much for being as patient as you were.
All right, everyone. Have a wonderful afternoon and a great weekend.
All right, happy Constitution Day.